Hey there, Bill O'Leary here. Happy Thursday to everybody. Welcome to our Thirsty Thursday series, something we do every Thursday. I'll just wait a few more seconds to let any of the stragglers jump in. But as I said, this is part of our Thirsty Thursday series. My name is Bill O'Leary from Legacy Planning Law Group, and um, every Thursday at this time, I'm going to be talking about a topic of interest as it relates to estate planning. So, let's go ahead and get started. And if you're thirsting for knowledge and information, then you have come to the right place. So, today's topic is, why is probate necessary? Why is probate necessary? You know, you may have heard about probate. It's a court process where your estate and the affairs are handled with the oversight of a probate judge and our wonderful court system, a process that moves at a snail's pace. You may have heard the horror stories of probate, maybe about how long it takes, often a year or more. Maybe you've heard about how expensive it is, often thousands or even tens of thousands of dollars. A lot of that going to the estate lawyer. Or maybe you've heard about how frustrating an experience probate is. And if you're like many people, you may have the desire to avoid the probate process because it can be public and lengthy and expensive. And for those reasons, many people try to plan their estate in the hopes of their family avoiding it. It can be done. There are ways to avoid bogging your family down in the probate court system. And often this is done by putting in place something called a living trust. And we here at Legacy Planning Law Group do that for people quite often. We put together living trusts for people all the time. A living trust is a great solution to the probate nightmare. But talking about living trust is a topic for another Thirsty Thursday talk. That's a topic for another day. Today, I want to talk about, why is probate necessary? You know, there are many reasons why opening of a probate may be necessary. And in fact, some important things can be accomplished through the probate process. So let's take a look at some of those reasons why probate is necessary. So let's say that the deceased person didn't have a will when they died. Well, the assets need to be probated. And why, you might wonder? Because going through the probate court process is the only way to get those assets out of the deceased's name and into the names of the heirs. You just can't transfer the assets that the deceased own straight to the heirs without the stamp of approval of a probate judge. And sometimes people are surprised to learn this. So, probate is needed if there's no will in place. But what if the deceased loved one did have a will when they died? Is that situation any different? Is probate necessary even if there is a will? Well, in many cases, a probate is still necessary even if the deceased had a will. You know, many people mistakenly believe that their family doesn't need to worry about probate as long as the deceased loved one had a will. This is a mistaken belief. In far too many situations, a probate is still necessary even if there is a will. Now, what can a probate accomplish had a will? Well, for one, the probate process can be used to determine the validity of the will. You know, in some cases, the will might not be valid. If the will is invalid, well, then the terms of the will can't be upheld and followed. I mean, for example, maybe the will wasn't properly, signed and witnessed. Maybe the will that's being presented to the probate judge isn't the latest one. Maybe the deceased signed a more recent will that changes things from an earlier will. Or maybe the will has mistakes in it or ambiguities that need to be explained and clarified by the probate court. Maybe the deceased signed a will by being pressured by someone to do so, what we call undue influence. Or maybe the deceased wasn't of sound mind when they signed the will. We call this having a lack of capacity. The probate court is there as a safeguard, or think of them as a gatekeeper to make sure that the will is genuine and legitimate so that the estate can begin to be settled as the deceased person wanted. Well, let's talk now about the executor of the estate. The executor, this is the person that handles the day-to-day affairs of the estate. Well, how does the executor get started? How do they know that they're the right person, the legitimate person to serve as the executor? Well, they need to be officially appointed. And the probate court really is the only way an executor can be officially appointed to serve on behalf of the estate. Sometimes the executor is named in the will. Other times there is no will, but the probate court can still appoint someone to serve as an executor. The court decides if the individual that's being appointed is properly qualified. And the probate court will look at several things. For example, their age, how old are they, what their relation is to the deceased person, what state they live in, and whether they have a criminal record. All of these are important factors for the probate judge to decide who's best to serve as executor. The probate judge will look carefully at whether the person not only meets these factors, but if they're also capable of handling the responsibilities as an executor to ensure that the estate's affairs will be in good hands. Now, another thing that the probate process can do is to protect and safeguard the deceased person's assets and property. It's very important to gather up the assets right away, what we call marshaling the assets. And this involves not only figuring out what the assets are, but also to protect and preserve the assets. For example, taking control of the house and securing the house. Now, of course, if the deceased died with a living trust in place, like I had mentioned, the trust itself will take care of this without the need for the probate court to get involved. But without a living trust, the probate court process can help protect and secure the assets. Now, during the probate process, extra care will be taken to ensure that the property that's described in the will, let's say, is in fact the property that the deceased person owned when they died. We want to make sure that the assets that are being listed in the estate are in fact the deceased person's assets and not someone else's. Again, having a living trust in place would go a long way to solving this problem. Now, another reason why probate may be necessary is to make sure that the deceased person's assets and their property are distributed to the heirs based on the instructions. Let's say that if the deceased had a will, the instructions in the will. If the will includes specific instructions, such as maybe specific assets going to specific people, then those instructions need to be carried out to the T. Or, if the will says that the deceased money will not be distributed outright to a beneficiary, but instead will continue on in some sort of lockbox for them, continue on, in fact, in a trust for them, then that trust needs to be formalized in the probate process, and the terms of the trust laid out by the deceased then need to be implemented. And of course, if no will exists, the property will be distributed based on Florida's inheritance laws, what we call intestacy laws. The probate court will make sure that those specific inheritance laws are followed. Now, do you think it's important to make sure that the beneficiaries themselves are legally able to accept the inheritance that they're designated to receive? For example, what if they're minors, or maybe even pets? Minor children and pets by law are not allowed to inherit money. The probate court can make this determination and set up legal ways for these otherwise ineligible beneficiaries to get their inheritance. Now, let's say there's a deceased person, let's say that owns some property or assets in their sole name without other joint owners. What happens to those assets? How are those assets transferred to the beneficiaries? Well, a probate often is needed to complete that transfer, especially if the deceased did not have a living trust, which would have solved the need to go through probate. A probate will be needed to get those assets out of the deceased name and into the names of the deceased person's heirs. Well, let's say that the deceased owned assets with someone else together as what's called tenants in common. Well, in this situation, the deceased tenant in common share will need to be probated to get it out of the deceased name and into the names of the deceased person's heirs or their beneficiaries. Or consider this situation. The deceased person owned a life insurance policy or maybe an annuity, and they didn't designate a beneficiary. Or maybe they did designate a beneficiary, but that beneficiary died before the deceased person did. Well, the death benefit payout on the life insurance policy or on the annuity contract will need to be probated in order to get the money into the names of the deceased person's beneficiaries. And in a similar fashion to life insurance or annuities, let's say the deceased owned a retirement account like an IRA or a 401k and maybe did not designate a beneficiary, or maybe they did, but the beneficiary predeceased them, died before they did. Well, that retirement account will need to be probated in order to get into the names of the deceased person's beneficiaries. A probate may also be necessary to make sure that all unpaid bills are paid up in an orderly way. It's vitally important that creditors of the deceased get paid first. Creditors get paid before the beneficiaries get their inheritance. If not, and if a creditor goes unpaid and all the money is distributed out to the beneficiaries, the executor is on the hook personally. A probate court, the court process, I should say, can be used to make sure that the estate's debts are properly evaluated. Only those claims that are valid need to be paid. Some claims may not be valid. And if there are multiple claims that are determined to be valid, what happens if there's not enough money in the estate to pay all of those creditors? Well, the probate process has a mechanism to pay creditors off in a priority order. What about the fees associated with administering an estate? You know, the executor is allowed to pay themselves a fee for their efforts. And of course, the attorney handling the sort of the legal aspects of the case will need to get paid as well. How are the amounts of these fees determined? How do they get paid? The probate court can serve an important role to give approval for these fees so that beneficiaries can't later complain about them. Of course, having a living trust in place would eliminate the need to get the court's approval for these fees, but unfortunately, a lot of people don't plan ahead to get a trust, and the family ends up getting bogged down in this court process that we call probate. And finally, a probate may be necessary to close the estate. There's a certain procedure to follow when closing out an estate. Now, of course, there's no need to get the court's help closing out an estate if the deceased had a living trust. That would be done by the trustee that's appointed by the deceased loved one, and it would be done privately without involving the court system. But if the deceased didn't plan ahead by getting a living trust, well, the probate court often is needed to formally close things out. Getting this finality is important so that the family has peace of mind knowing that everything is done and nobody can come in later to cause a problem. So as I wrap things up, hopefully you can see many things can be accomplished through the probate process. Yes, it can be very expensive and time consuming to do all of these things through the court system. A simple solution is to put together a living trust which will avoid all of this. So if you'd like to know more about why probate may be necessary, or better yet, how to avoid probate and how a living trust is a great way to do it, we'd be happy to talk to you. You can book a free 15-minute phone call with our team. Just go to the main Facebook page for Legacy Planning Law Group and select the Book Now button. This call would give you a chance to tell us what your concerns might be and what your situation is, and it would also give us both a chance to see if we might be a good fit for each other. Again, that call is complimentary. Or if instead of booking a call, you'd rather just call the office, you can do that at 904-880-5554. 880-5554, or if you're not even ready to do that, you just want to sort of scope us out on the internet, you can Google us, Legacy Planning Law Group, and go to our website. So I hope you've enjoyed this talk on why probate is necessary. Again, as I said at the beginning, I plan to give another Facebook Live Talk again next Thursday afternoon at this time as part of our Thirsty Thursday series. Same day and time, but a different topic. So if you're thirsty for knowledge, we will quench your thirst. So this is Bill O'Leary signing off for now, and on behalf of our entire team here at Legacy Planning Law Group, what we affectionately refer to as Team Legacy, we want to thank you for spending some time with us, and go make it a great day.